Stop what you're doing right now, because something happened inside the American federal court system this week that is so staggering, so jaw-dropping, so utterly beyond anything that should ever occur in a functioning democracy, that when you hear the full story laid out from beginning to end, you are going to feel that cold, uncomfortable sensation that comes when you realize the country you thought you lived in and the country that is actually operating right now are two very different places. We're not talking about politics. We're not talking about left versus right, Democrat versus Republican. We're talking about federal judges, judges appointed by Donald Trump himself, judges appointed by Bill Clinton, judges appointed by Barack Obama and George W. Bush and Ronald Reagan, all of them across party lines, across every ideological background, reading the conduct of Donald and Trump's Department of Justice and using language in their written court orders that you simply do not see in American legal history. Words like surreal intonine phrases like, give me a break, orders describing what the Trump DOJ is doing as a masterclass in litigation cynicism, and in courtroom exchanges so extraordinary they barely feel real, a federal judge demanding that Trump's top law enforcement official put his own statements under oath, and that official refusing to do it. The most powerful law enforcement agency in the world, refusing to swear to what it is already saying out loud. Let that sink in for just a moment, because by the time we are done here, you are going to understand exactly why that refusal is the most terrifying detail in this entire story. Let's start with Judge Kyle Dudek. Judge Kyle Dudek was born in 1985 in Syracuse, New York. He went to Cornell University and George Mason University for law school. He was appointed by Donald Trump and has served as a U.S. District Judge in the Middle District of Florida since 2025. This is not some Obama judge. This is not some deep state operative. This is a young Trump-appointed federal judge who was nominated by Trump, confirmed by a Republican Senate, and installed on the federal bench as part of Trump's own judicial legacy. And this week, Judge Dudek issued an order that is going to be studied in law schools for decades, not because it broke new legal ground, but because of what it reveals about the Trump administration's complete and total contempt for the rule of law, and because even Trump's own hand-picked judge could no longer look the other way. The case involves a man named Dmitry Yastrobov, a non-citizen sitting in immigration detention. The court had already ordered the government to provide him with an individualized bond hearing after the government itself conceded it was wrong for not giving him a bond hearing. This is the part that needs to sink in. The government admitted it was wrong. The government told the federal court, "You're right, Judge, we made a mistake. This person deserves a bond hearing." The court issued its order. Case resolved, right? Wrong. Because what happened next is what Judge Dudek described with a phrase that should alarm every American who still cares about the idea that the courts in this country mean something. What happened next, Dudek wrote, borders on the surreal. 5 days later, an immigration judge refused to hold the ordered hearing, claiming Yastrobov was not covered by the statute and thus ineligible for bond. Instead of defending the court's mandate, the government's counsel acquiesced in that refusal and waived any administrative appeal. Read that again slowly. The Trump DOJ went into federal court, made a concession, got the court to close the case on the basis of that concession, and then, instead of actually complying with what the court ordered, quietly stood by while one of their own administrative judges, who are not neutral federal judges but employees of the Department of Homeland Security, essentially nullified what the federal court had ordered. And then, when the man's lawyer brought it back to court, the DOJ had the audacity to walk back in and say, "Actually, our earlier concession was a mistake. Please reverse your entire ruling and start over." Judge Dudek was unsparing. "The government was right the first time," he wrote, "and its request for a do-over here is not just legally unsupportable. It is a masterclass in litigation cynicism. A federal court is not a testing lab where the executive branch can pilot a concession to get a case closed, stand by silently while its own administrative process flouts the resulting mandate, and then stroll back in demanding a clean slate. A federal court is not a testing lab. A Trump-appointed judge writing those words about Trump's own Department of Justice. Think about what it takes to push someone you appointed to that level of open, documented fury in a written court order. Think about how many times this must have happened before a judge who was installed to be friendly to this administration finally hit his limit and said in plain English, "Give me a break." And then Judge Dudek did something that is worth understanding in its full legal and human context. He didn't just grant the habeas petition. He didn't just order the bond hearing again. He ordered the man's immediate release. Because here is the legal logic that Judge Dudek applied, and it is bulletproof. If the government cannot be trusted to follow even the most basic judicial directions, then sending this man back through the same administrative process that was already manipulated once is not a remedy. It is a trap. It is a performance of compliance, while the outcome is being rigged from inside. And so the judge said, the only remedy that law and justice require is immediate release. Dudek ordered Yastrebov's immediate release from detention, giving the government 48 hours to comply, and directed the government to facilitate his transportation and notify his counsel of when and where he could be collected. Notice the specificity of that last instruction. The judge had to spell out in a written court order exactly how to hand a released detainee back to his own lawyer. He had to put that in there explicitly because the Trump administration has a documented history of releasing people without their cell phones, without notifying their attorneys, dropping people without documentation into conditions where they have no means of contacting anyone. We have seen people die as a result of exactly that kind of processing. And so Judge Dudek, a Trump appointee, had to write into his own order a step-by-step guide for how to treat a human being with basic dignity upon release, because the pattern of conduct from this administration has demonstrated that without that instruction in writing, it might not happen. Now here's the context that makes this single case not just important, but historically significant. A Politico analysis documented more than 10,000 rulings that federal judges nationwide, appointed by Republican and Democratic presidents alike, have issued against the Trump administration's mass immigrant detention policy. 10,000 rulings, from judges across the entire ideological spectrum of the American federal judiciary, not fringe decisions, not activist outliers. The broad, overwhelming consensus of the American federal court system, including judges that Donald Trump himself put on the bench, has looked at this administration's immigration detention policy and said, consistently, in case after case after case, this is unlawful. Former Justice Department Inspector General Michael Bromwich put it plainly, district court judges around the country, appointed by Republican and Democratic presidents alike, are serving as the strongest guardrail against the incursions on the rule of law. And what has the Trump administration's response been to 10,000 judicial losses? They keep doing the same thing. They keep trying the same maneuver in slightly different forms. They keep walking into courts, making arguments that have been rejected thousands of times, getting those arguments rejected again, and then either ignoring the order, routing around it through their administrative apparatus, or coming back weeks later asking for a do-over as if the previous order never existed. Judges across the country have reportedly grown increasingly furious and exhausted as the Trump administration continues to openly defy court orders on mass immigration enforcement, with courts proactively threatening to hold Trump administration officials in contempt. Furious, exhausted. These are not words anyone should want associated with the judiciary's relationship to their government's law enforcement arm. These are warning signs. These are the sounds of an institution being pushed toward a breaking point. But the Yastrebov case and the 10,000 ruling reality of immigration court chaos are only one half of what exploded in the courts this week. Because in a federal courthouse in Alexandria, Virginia, a completely different kind of legal confrontation was unfolding, and it may be even more disturbing in what it reveals about how this administration operates. Because this one isn't about immigrants. This one is about money. American taxpayer money. Nearly $2 billion of it, funneled by Donald Trump's own Department of Justice into a fund that even some Republicans in Congress called one of the most corrupt things they had ever seen in American government. Here is the background you need to understand this fully. The Trump DOJ created a so-called anti-weaponization fund designed to compensate individuals who alleged they were unfairly targeted by the government. The fund would receive $776 billion from the Federal Judgment Fund, a permanent Treasury appropriation used to pay certain legal settlements and judgments against the federal government. Now, on its face, if the government genuinely wrongs someone, compensation is a legitimate concept. But here's who this fund was actually designed to pay. Vice President J.D. Vance and Acting Attorney General Todd Blanche both declined at separate events to rule out the fund making payouts to Jan. 6 rioters who attacked police. As senators from both parties noted in a brief filed in the case and read aloud in court, among the fund's purposes was to compensate the insurrectionists who stormed the U.S. Capitol on January 6th. The roughly 1,500 January 6th rioters President Trump pardoned are among those most likely to profit from the fund. Let that register. $1,776 million of your tax money, designed in substantial part to write checks to people who attacked the United States Capitol, beat police officers with flagpoles and fire extinguishers, smashed through windows, erected gallows outside the building, and tried to prevent the constitutional transfer of power. Trump pardoned them, and then Trump's DOJ created a fund to pay them. With your money? One law professor at USC Gould School of Law said, "I don't even think we have a word for how unprecedented this is. This is in a totally different solar system than any past government settlement on record." Not an exaggeration for political effect. A legal scholar on the record saying, "American legal history has no framework for what just happened because nothing like it has ever been attempted before." U.S. District Judge Leonie Brinkema ruled that the DOJ could not begin setting up, funding, or distributing payments from the fund while litigation is pending. But here is where this becomes the second chapter of a story that, taken together with the Yastrobov case, tells you everything you need to know about how the Trump DOJ actually operates. Because after Brinkema blocked the fund, Acting Attorney General Todd Blanche went to Congress and, in testimony before a House committee, said that the fund is dead, it's not going forward, we're done with it, not going to happen. Very clear, very definitive statements made before Congress. Except, and this is the crucial detail, he wouldn't put it in writing, he wouldn't sign anything. He wouldn't swear to it under oath, he just said it out loud and expected that to be the end of it. The Atlantic reported that even as the DOJ was publicly claiming the fund was dead, administration officials were quietly reassuring Trump's cronies behind the scenes that they would still get their checks, and that the administration simply needed to wait for the legal blowback to die down or find an alternative way to award them the money. So what the Trump DOJ was allegedly doing, if that reporting is accurate, is going into court and saying one thing, telling Congress one thing, saying publicly that the fund is over, while privately telling the people who were supposed to receive the money, don't worry, we're just waiting for the coast to clear. You will get paid. That is not just a lie. If true, that is fraud. That is what fraud upon a court actually means, making representations to a judicial body that you know, at the moment you make them, to be false. And so Judge Brinkema did something that was simultaneously very simple and profoundly significant. She gave Blanche and Treasury Secretary Scott Bessent 1 week to submit written sworn declarations that the fund was not going forward. That's it. If the fund is really dead, if Blanche's testimony to Congress was the truth, then signing a sworn declaration saying the same thing should take approximately 30 seconds. It is the most basic ask imaginable. You said it, now sign it, put your name on it, under oath, with legal consequences if it turns out you were lying. Judge Brinkema ordered Acting Attorney General Todd Blanche, Associate Attorney General Stanley Woodward Jr., and Secretary of the Treasury Scott Bessent to file a declaration affirming they would not take any action to create or operate the anti-weaponization fund, and that the fund would not proceed in any manner or under any name. That 3-word addition tells you exactly how much Judge Brinkema trusts this administration. She wasn't just blocking the fund, she was blocking every possible version of the fund that might get rebranded and relaunched the moment the legal pressure eased up. Under any name. She has seen how this works. She knows the playbook, and she's not going to let it happen on her watch. Plaintiff's counsel said she honestly did not believe that Blanche and Bessent would put it in writing, saying it would tell the court a great deal that they had represented they were terminating the fund, but there was no evidence to support that. Think about what that means coming from a lawyer in open court. She is predicting, out loud to the judge, that the Acting Attorney General of the United States of America, the top law enforcement officer in the nation, will not be able to sign a single piece of paper confirming that he is telling the truth, because she believes he is not telling the truth. And she is saying that to a federal judge's face, because the pattern of conduct from this administration has made it the reasonable, logical, professionally sound prediction. Here is the thing that connects Judge Dudek's order in Florida to Judge Brinkema's order in Virginia, and the thing that makes this week not just 2 separate legal stories, but one coherent, terrifying picture of what is happening to American governance. In both cases, the Trump administration's strategy is identical. Make a representation to get a case closed or make legal pressure go away. Then either ignore the ruling, route around it, or wait for the spotlight to move elsewhere before resuming the conduct that generated the legal challenge in the first place. In the Yastrobov case, they made a concession, got the order closed, then had their own administrative apparatus quietly nullify the order, while their DOJ lawyers stood by and said nothing. In the slush fund case, they publicly declared the fund dead, while allegedly privately reassuring recipients that payment was still coming, and refused to put anything in writing that could be held against them later. This is not incompetence. Incompetence looks different. Incompetence is making mistakes, losing cases, getting rulings wrong, and then genuinely trying to comply and failing. What we are watching is something deliberate. It is a systematic strategy of using the formal language of legal compliance, making concessions, saying the right words in court, testifying before Congress, while preserving the actual operational ability to continue doing exactly what the courts and Congress have told you to stop doing. It is the use of legal process as camouflage for lawlessness. And federal judges, Trump judges and otherwise, have now started to see it clearly enough that they are writing it into their orders in language that has never appeared in American federal court jurisprudence before. Of the more than 10,000 rulings against the Trump administration's mass detention policy, the winning percentage overall has been described as abysmal. To put this in historical perspective, the Nixon administration, at the height of Watergate, with courts pushing back on executive overreach at every turn, never generated anything close to this volume of judicial defeats. The Bush administration's post-9/11 legal battles, which were some of the most contested executive power cases in modern American history, played out over years and through the appellate system in ways that looked nothing like what is happening here. What is happening here is a wholesale, administration-wide, daily repeated refusal to accept that federal courts have the authority to tell this executive branch what to do. And the courts, all of them across every ideological line, are pushing back. The deeper question that this week's events force every American to confront is this: what happens to a democracy when the executive branch decides that court orders are optional? What happens when the entity responsible for enforcing the law is the same entity that keeps treating legal compliance as a negotiating position? The courts can issue orders. They can hold people in contempt. They can release detainees, freeze funds, require sworn declarations. But ultimately, the enforcement of court orders depends on the willingness of the executive branch to comply. That is not a flaw in the design of the American system. It is a feature that was built on the assumption that no administration would be willing to sustain the reputational and institutional damage of open defiance of the federal judiciary. That assumption is now being tested in real time, in case after case, day after day, by a Department of Justice that has now been called out by its own hand-picked judges using language that belongs in a civics textbook as a warning about what the collapse of the rule of law looks like from the inside. Judge Kyle Dudek was put on the federal bench by Donald Trump. He is 40 years old. He went to Cornell. He is not an Obama holdover. He is not part of some deep state conspiracy. He looked at what Trump's own DOJ did in his courtroom, the concession, the silent sabotage, the casual demand for a do-over, and he called it a masterclass in litigation cynicism and ordered immediate release as the only remedy that law and justice require. Judge Leonie Brinkema looked at the acting Attorney General of the United States, listened to him refuse to sign his own words, and told him, put it in writing under penalty of perjury, or this case continues. These are not radical acts. These are the most basic acts of judicial oversight imaginable. The fact that they feel extraordinary, the fact that they are generating national news coverage, the fact that judges are having to write the phrase, "give me a break," in federal court orders, that tells you everything about how far we have already traveled from where a functioning democracy is supposed to be. The rule of law is not an abstraction. It is not a talking point. It is the actual operational foundation on which everything else in this country is built. Every contract, every property right, every business transaction, every election, every criminal prosecution, every civil liberty, all of it rests on the premise that when a court issues an order, it will be followed. When that premise is eroded, not broken all at once, but chipped away, case by case, courtroom by courtroom, surreal ruling by surreal ruling, the damage is not immediately visible. It accumulates. And when it accumulates long enough, one day you look up and realize that the institutions you thought were protecting you have been hollowed out. And the only people still standing in the breach are a handful of federal judges, some of them Trump's own appointees, writing phrases like, "give me a break" into court orders and hoping that someone is paying attention. This week, people were paying attention. The question is whether they will keep paying attention next week, and the week after, and every week after that. Because this administration is counting on them not to.